dawn on Pearl Harbor. This pictorial record includes both U.S. films and pictures made by the enemy as they drop their load of death on the naval base, on Wheeler Field, on civilian homes and schools. 100 Japanese planes and a number of midget submarines took part in the attack. In an hour and 5 minutes, the battleship Arizona
Ladies and gentlemen, we're standing by for further word from Honolulu, and we expect to rejoin them in just a moment. However, here's the bulletin which has just come into the NBC newsroom in New York. From Europe, the Japanese ambassador and Kurusu, the special Japanese envoy, were at the State Department at the time of the White House's announcement of the attacks on Hawaii. The two Japanese went to the Secretary of State Hall at 1:35 p.m. Eastern Standard Time and remained about 20 minutes. Back in New York City, here's the bulletin. Honolulu, Japanese bombs killed at least 5 persons and injured many others, 3 seriously, in a surprise morning aerial attack today on
Evacuation. More than 100,000 men, women, and children, all of Japanese ancestry, removed from their homes in the Pacific Coast states to wartime communities established in out-of-the-way places. Their evacuation did not imply individual disloyalty, but was ordered to reduce a military hazard at a time when danger of invasion was great. 2/3 of the evacuees are American citizens by right of birth. The rest are their Japanese-born parents and grandparents. The people are not under suspicion. They are not prisoners. They are not internees. They are merely dislocated people, the unwounded casualties of war. The entire community bounded by a wire fence and guarded by military police, symbols of the military nature of the evacuation. They know what they're fighting against, and they know what they're fighting for. Their country, and for the American ideals that are part of their upbringing. Democracy, freedom, equality of opportunity, regardless of race, creed, or ancestry.
Camps officially began to close. Going home was the next challenge.
They felt that they would be greeted with hostile neighbors and so forth. And word also came back that many of their farms had in fact been destroyed, torched by people.
For all the fear of sabotage that led to internment, by the end of World War II, not a single person of Japanese ancestry in the United States had even been accused of sabotage.
The wounds were so deep that the Japanese American community refused to discuss the internment for many years. In the late 1960s, during the Civil Rights Movement, a reparations movement emerged. Yet it took 2 decades before Japanese Americans took legal action in 2 different kinds of lawsuits to support the reparations movement. The first lawsuit in 1983 was the Coram Nobis litigation. It was initiated by Fred Korematsu, Gordon Hirabayashi, and Min Yasui, who had been convicted during World War II for refusing to be interned.
Nami and his team brought the Korematsu case back to federal court under a motion that is rarely used and almost never successful, Coram Nobis,
which was a rare legal procedure allowing the reopening of old cases of current importance. The Supreme Court had said at the time that the internment was constitutional because military necessity justified it. 40 years later, the Coram Nobis proceedings sought reversal of their convictions based on startling government World War II documents. Those documents revealed the following. 1. Before the internment, all government intelligence services involved in the issue at the time had determined that West Coast Japanese Americans as a group posed no serious danger and that there was no basis for mass internment. 2. The military based its internment decision on ambiguous racial stereotypes about Japanese Americans. 3. The Department of Justice and the Department of War concealed and destroyed key evidence that deliberately misled the Supreme Court and fabricated the military necessity justification for the internment.
Fred Korematsu waited 40 years before he got the chance to clear his name. He joined up with a team of young lawyers led by Dale Manami.
Courts must be allowed to function even during times of crises and should not be subjugated to the will of an arbitrary military decision maker.
Based on this evidence, the federal courts in the Coram Nobis cases found manifest injustice, overturned the convictions of Korematsu, Hirabayashi, and Yasui cases, and thereby laid the legal foundation for reparations.
I had to do some real deep thinking in order to reopen this case again, and I am very happy that I did, because this is not only for just the Japanese American citizens, but it's for all American citizens.
The second suit was a class action damages lawsuit, Hori versus United States, which was filed by former attorneys to obtain compensation for the material and psychological harms of the internment. Although the courts ultimately dismissed that case because it was filed too long after the events, the suit led to a greater public awareness and education about the real internment story. The reparations movement gained moral force from former attorneys and Asian American organizations, together with a wide range of groups, including civil liberties groups, the NAACP, churches, veterans and labor associations, and even local governments. This support helped Asian American members of Congress from California and Hawaii to push through legislation creating the Commission on Wartime Relocation and Internment of Civilians. The Commission's 1983 report, Personal Justice Denied, concluded that the causes of the internment were racial prejudice, wartime hysteria, and failure of political leadership.
In 1988, Congress passed the Civil Liberties Act, which not only apologized for the internment, but paid each survivor of the camps $20,000. The act was signed by President Ronald Reagan and sponsored by Congressman Norman Mineta.
The legislation that I am about to sign provides for a restitution payment to each of the 60,000 survivors, surviving Japanese Americans, of the 120,000 who were relocated or detained. Yet no payment can make up for those lost years. So what is most important in this bill has less to do with property than with honor. For here we admit a wrong. Here we reaffirm our commitment as a nation to equal justice under the law. Thank you all again, and God bless you all. I think this is a fine day.
Most important for many Japanese Americans, the act called for a formal presidential apology. It also authorized reparations of $20,000 for each surviving internee who was a U.S. citizen or legal resident immigrant at the time of internment. The purpose of the Civil Liberties Act of 1988 with respect to persons of Japanese ancestry included the following. 1. To acknowledge the fundamental injustice of the evacuation, relocation, and internment of citizen and permanent resident aliens of Japanese ancestry during World War II. 2. To apologize on behalf of the United States for the evacuation, internment, and relocation of such citizens and permanent residing aliens. 3. To provide a public education fund to finance efforts to inform the public about the internment so as to prevent the recurrence of any similar event. 4. To make the restitution to those individuals of Japanese ancestries who were interned. And 5. To make more credible and sincere declarations of any concern by the U.S. over violation of human rights committed by other nations.
The Office of Redress Administration, created by the Act, implemented the reparations program. The Act authorized the ORA to identify, register, verify, and administer reparation payments to eligible individuals within a 10-year period. The ORA worked effectively with the National Coalition for Redress Reparations and the Japanese American Citizen League to provide information about reparations through Japanese American newspapers, community meetings, and newsletters. Former attorneys submitted over 60,000 reparation applications as a result of these collective efforts. The 1988 Act also established the Civil Liberties Public Education Fund to sponsor research and public educational activities to publish and distribute the hearings, findings, and recommendations of the Commission. Public education became a major dimension of redress. Projects sponsored by the Education Fund produce high school, college, and law school curricula on the internment and civil liberties, documentaries on internment camp life, oral histories of survivors, and the new research on the accommodation of national securities and civil liberties. The redress of wrongs committed against Japanese Americans was about much more than money. The Civil Liberties Act recognized the United States' grave injustice against its own citizens on account of their race, and it acknowledged the need to repair lasting wounds both to Japanese Americans and to the Constitution. In Woodland, Washington, Alan Northrop was arrested and sentenced for the rape and kidnapping of a housekeeper and was sentenced to 23 years in prison, leaving behind his family. Detectives believed the victim's story, even though she was blindfolded for most of her attack. Northrop tried to prove his innocence and in 2000 contacted the Innocence Project Northwest at the University of Washington School of Law in Seattle. For years, prosecutors denied their project's request to use more advanced DNA testing on the evidence in Northrop's case until 2005, when a new state law gave judges the power to order additional testing. However, it took another 5 years for Northrop's testings to be completed and for the court to consider. In 2010, Northrop received a letter that finally granted his release. He walked out of prison a few months later, but because he was convicted in Washington, like 23 other states across the country, Washington provides no compensation for those who have been wrongfully convicted. Northrop left prison with less than $2,500. He had been convicted in one of the 27 states that do not provide compensation. Northrop could have received hundreds of thousands of dollars for his 17 years behind bars. According to the Innocence Project study, Northrop is among the 40% of exonerated prisoners nationwide who have received nothing. The reports call for all states to pass laws providing the same compensation that the federal government offers to federal crimes, $50,000 for each year spent on death row. He claims that it's not all about money. It's about possible counseling for certain individuals.
And what you go through in there mentally is just traumatic. It's something that's not even fathomable. It's not right.
I am a Filipino soldier here in the foxhole or in the trains in the front line. American also is here. We fought side by side with the same uniform, with the same dangers and bullet. We are facing the Japanese. That is what we call fought side by side with U.S. Army soldiers under the U.S. flag.
After the war was won in 1945, a U.S. law denied most Filipino soldiers U.S. veteran status, preventing them from receiving benefits such as medical care and a pension.
The Americans promised it, but it never came. Some of us have gone to America to ask the government for recognition. I went to America many years ago, but came back empty-handed.
Now, more than 60 years later, the United States Congress finally passed a bill providing $98 million in compensation to the estimated 20,000 living Filipino veterans. Beda Carrion, who endured aching legs to apply for the one-time lump sum payment of $9,000, described it as a victory he thought would never come.
We have waited so long for this. Sometimes, all of these years of waiting, I felt disgusted about America's attitude. Can you imagine how long it took them? There used to be more than 30 veterans in this area, but now only 5 are left.
But with their advanced age and poor health, some worry they still would not live to see the day when a check finally arrives. They say time is running out.